Hi, my name is Barrister Kelvin. I advise you on legal education. To provide knowledge and information on laws governing the society today, I would be talking on negligence. Negligence 1. Meaning of negligence. Negligence is a tort that arises where a person fails to exercise reasonable care, resulting in damage or injury to another. A classic definition was given by Winfield. Negligence is the breach of a legal duty to take care which results in damage to the plaintiff. Also, in Donahue v. Stevenson, negligence was firmly established as a separate tort. 2. Elements of negligence. To succeed in an action for negligence, the plaintiff must prove 3 essential elements. A duty of care. This means the defendant owed the plaintiff a legal obligation to take care. The foundation of this principle is the neighbor principle, stated by Lord Atkin in Donahue v. Stevenson. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would likely injure your neighbor. Examples of duty of care: doctor to patient, driver to road users, employer to employees. B. Breach of duty. This occurs when the defendant fails to meet the required standard of care. The standard used is that of a reasonable person. Case: Blythe v. Birmingham Waterworks. Negligence is the omission to do something a reasonable man would do. Factors considered: likelihood of harm, seriousness of injury, cost of preventing harm. C. Damage, resulting harm. The plaintiff must prove actual damage. 2 key tests apply. I. Causation. But for test, would the damage have occurred but for the defendant's act? Case: Barnett v. Chelsea Hospital. 2. Remoteness of damage. The damage must not be too remote. It must be reasonably foreseeable. Case: The Wagon Mount. No. 1. 3. Types of negligence: ordinary negligence, general failure to take care, gross negligence, extreme carelessness, professional negligence, negligence by professionals, for example, doctors, lawyers. 4. Defenses to negligence: A. Contributory negligence, where the plaintiff also contributed to the harm. Damages may be reduced. B. Volenti non fit injuria, consent, where the plaintiff willingly accepted the risk. C. Act of God, natural events beyond human control. D. Inevitable accident, an accident that could not have been prevented despite reasonable care. 5. Remedies for negligence. The main remedy is damages, which may include general damages, pain and suffering, special damages, financial loss. 6. Conclusion: negligence is a fundamental aspect of the law of tort. It ensures that individuals act with reasonable care to avoid harming others. To succeed, a claimant must establish duty, breach, and resulting damage.